Everyone, got it. Okay. Half a day, everyone. I'm, of course, as most of you know, I'm Judge Tynico Gatewood. We have a lot of attorneys who have signed up both from Guam and the NMI, so we appreciate you coming here today and participating in today's session and for your interest in consumer bankruptcy. I put this together and it has some of the experts in the field because of the shortage of attorneys, both on Guam and the Northern Mariana Islands. Judge Manglone and I have spoken about that. We have, as many of you know, we've had a shortage of debtor attorneys on Guam. Part of it is retirement, aging out, interest, and so forth. And we've reached out to some lawyers who are interested in developing the practice. So I've asked two bankruptcy judges who are very familiar with Guam and the Northern Mariana Islands, our assistant U.S. trustee and a consumer debtors counsel. Judge Faris and Judge Collins are both designated here on Guam. Judge Faris is a chief bankruptcy judge who has worked very closely with me in the Archdiocese bankruptcy case where we had 230 claimants, and he settled that case, and he helped me in the CNMI retirement fund case. Judge Collins, and Judge Faris is from Hawaii. Judge Collins is from Arizona, who's going to serve as a moderator. He's been a bankruptcy judge in Arizona since 2013 and is a fellow in the American College of Bankruptcy and the NCBJ, and is on the Ninth Circuit's Trial Improvement Committee, has worked on many cases here, mostly the subchapter 5 cases, and just recently settled the Asia Pacific case. Curtis Ching has been our U.S. trustee. And last but not least, Ms. Krystal Ahart. Is it Ahart or Ahart? Okay, so she's from Phoenix since 2012. Her focus is on individual and commercial clients through the Chapter 7, 11, and 13 bankruptcies. I hope that you're truly interested in bankruptcy, and for those of you who are, we're going to work closely with mentors, including the individuals here today and some attorneys out of Hawaii as well. So as my hope is that we provide you all the tools necessary to have you competently practice both on Guam and the Northern Mariana Islands. So may I pass this on to our island brother, Judge Collins from Arizona. Judge Collins.
Thank you very much, Judge Tynico Gatewood. It's been a pleasure working with you these last few years, and it's great to see you on the screen today. So this is a little bit different than the ordinary seminar where you have some subject matter experts who basically are there to frighten you and make sure that they are going to get referrals going forward because they're going to make sure you don't feel comfortable doing it yourself. We're taking exactly the opposite approach because we think you, like us, should love bankruptcy and that you should feel comfortable doing bankruptcy and feel like it's an important part of your practice to learn a little bit about bankruptcy so that you can spot some of the issues. So at the end of the day here, we hope you will take away some of the love we've got for the bankruptcy code and the bankruptcy practice. And so I'm particularly thrilled to have Judge Faris here. He's a bankruptcy appellate panel judge. He grades my homework, and I'm very conscious of the fact that I need to go easy on him today. And so Judge Faris, thank you very much for being here. Now, Curtis Ching and I have actually done a seminar before in Guam at the last time the Guam District Court convened, and we did a bankruptcy academy. So Curtis, it's really great to be working with you again on this one. Now, Krystal Ahart, she's new to the whole Guam scene, but she is a very experienced practitioner in Arizona. And when I thought about lining up this panel, I brought Krystal in because she's a great public servant, and it's just really fun to work with her, and she's highly organized as well. So she, however, primarily represents the debtor's perspective. And so I think you're going to see some things that you're not necessarily going to see in regular bankruptcy seminars, in that she's going to tell you a little bit about how you build your practice and some of the things you're going to want to do as you build your practice and some sort of the bells and whistles that come along with being a debtor's lawyer. And most importantly, for those of you wondering how in the world could I make money at practicing bankruptcy law, she will help point the way a little bit about how you can actually make a good living doing consumer debtor work, at least as an adjunct to your regular practice. So with that, let's go ahead and get started. I'm going to start with the screen share here and just remind everybody who you're looking with here today. Krystal, can everybody see this all right?
Yep, looks great.
Okay, so we're going to move past that. We're going to start off discussing some of the various bankruptcy chapters, particularly chapter 7 and 13 are going to come into play here today. You've heard of those before, but we're going to talk a little bit about what those mean. We're going to talk about some of the strategies that you're going to be looking at even before you file a bankruptcy, or maybe I should say specifically before you file a bankruptcy, so you know which direction you're headed. And some of those pre-filing considerations we're going to walk through today. Everybody wants to get paid in these cases if you're not doing it on a pro bono basis, and we're going to help highlight some of those things for you and perhaps point out a few of the ethical issues. But again, we're not here to scare you out of the practice. We're trying to encourage you to think about doing some of the practice. So with that, Curtis, why don't we start with you and talk a little bit about this screen, some of the things that may drive somebody to consider a bankruptcy in the first place.
Thank you, Judge Collins. Hello, everyone. So yes, this first discussion topic is going to be on creditor collection efforts. It's kind of like what drives individuals to file for bankruptcy. And it's not going to be any great revelation. It's going to be people basically getting sued in some fashion or another. So foreclosure is oftentimes the driver for bankruptcy filings, particularly on the eve of a foreclosure sale. There's collection lawsuits. Sometimes people will file when they get sued. Other times they will wait till after a judgment is entered. And so post-judgment debtor examination is coming up, and that scares them. Sometimes the recordation of a judgment lien on their home will cause them to file. Repossession efforts, particularly on automobiles, is an item because people, I know on Guam and Hawaii, I mean, you need your car to get around. And so if you don't have that, you're in real big trouble. Wage garnishments, if you have a judgment and you end up losing a monthly amount, that often drives people into bankruptcy. Bank account garnishments, same thing. Charging order, something that allows a creditor to execute on a judgment. And one of the items that's not even listed is an eviction, if they're just behind on rent. And what they're trying to do is delay or stop the landlord from kicking them out. So debtors can come to you with a varying degree of urgency. You'll need to examine all aspects of their financial condition to determine, number one, whether they should file. And number two, if they should file, what chapter would be the most advantageous. So those are some of the creditor collection efforts.
Now, Judge Faris, sometimes I see people filing a bankruptcy because there is actually an appeal that they want to take from a state court judgment, but they can't afford to post the bond. Do you ever see that when you're doing your bankruptcy appellate panel work?
Sure, quite frequently. People have suffered an adverse judgment. They think the judgment was wrong. They want to appeal. They can't afford the bond or other security to get a stay pending appeal. They file a bankruptcy that gets the automatic stay in place, which protects them from collection efforts in the meantime. Sometimes that doesn't work. Sometimes people will say, well, that's a bad faith bankruptcy filing, but at least in the short run, it does work. It gets you a stay.
Okay. Do you see other scenarios where efforts are happening to a debtor that might drive them to bankruptcy beyond the list of what Curtis talked about?
I think Curtis covered most of them. Here in Hawaii, the foreclosure is the most common. People are in the middle or towards the end of a foreclosure, somewhere in that process. They need a little more time to try and negotiate a loan modification with their lender, or they want to come up with a catch-up plan to catch up on their mortgage arrears. They'll file a bankruptcy to do that. Another big driver here in Hawaii is the wage garnishment. Under our law, a creditor can take 25% of your after-tax income. And, think of anybody in your life who could afford an immediate overnight 25% pay cut. Those people need bankruptcy help.
Great. Now, Krystal, you're in Arizona, but you're the one talking to debtors all the time. Any other issues that you see drive them towards a bankruptcy or to your office?
I mean, I think that list really does cover it. I think the foreclosures, just as in the other jurisdictions, is very common here. And gratefully, we've got a new mortgage modification program that we can use and tap into within the bankruptcy case to help address those foreclosures. But Chapter 13, one of the available chapters to most individuals, allows for the curing of a past due mortgage arrearage over time. So even without a special program in the bankruptcy court, there are lots of options to help address foreclosures. But again, I think, and Curtis is right to point out that eviction is not on this list. That's a common one that we see, but I think this list pretty well covers it.
Okay, so this is what drives people to your office, but now that they're in your office, let's talk about whether they're actually a candidate for bankruptcy, Krystal.
Yeah, and I think, a common question is how much is enough debt, right? What is enough debt to make me file? And I think that is just a relative answer. It's more factors like you see on your screen. Can they pay all their debts as they're coming due? If they can pay, but they're only paying a minimum payment, as we all know, especially if we're talking about credit card debt, the interest accrual is something that a lot of times people can't overcome in their lifetime. I appreciate that now on our credit card statements, it has to give more information to the debtors about how long it's going to take, 35, 40 years for you to pay it off if you only pay the minimum payment. I think that makes it more real to people, more tangible to people, that even if I'm, doing what I can to pay what I can every month, it may be something that I can just never overcome in my lifetime. And that is a reason. And that's different for everyone. That's different for someone that's 30 and someone that's 50 and someone that's 70, and different based on their circumstances in addition to just their age. But large litigation matters or sizable judgments, as Curtis referenced, when there's a big judgment, there's often judgment debtors examinations coming down the pike. And not having representation in those sorts of matters is daunting, risky, challenging, emotionally a burden for the debtors, and that snowball can become very large behind people, and that how big that snowball is really the question, is how much can that person withstand? Are they at the point, as they often are by the time they come to me, that they just can't withstand that snowball growing any larger? If there's still assets to preserve, it's someone that's still working a wage job, as we've talked about, wage garnishments can be a really severe financial impact, and something, again, that maybe they could never overcome in their lifetime. And so, filing a bankruptcy to stop that garnishment for good is obviously a very beneficial option for many people. There's a specific provision in the bankruptcy code that allows us to remove or avoid judgment liens. So Curtis referenced the recordation of a judgment can create a lien on a real property. Here in Arizona, there's been recent changes, and that becomes a lien on a homestead property as well. But to a certain extent, some of that can be addressed through a bankruptcy case and specific motions that can be filed within a bankruptcy case. So bankruptcy is a very powerful tool in a lot of different ways. And we'll talk a little bit more about tax obligations as we go down the pike, but bankruptcy also provides avenues for addressing tax debt, tax obligations. Sometimes at the, go ahead.
No, go ahead, Krystal.
I was just going to take us to the next slide, so you go ahead.
So
yep.
Now you're at the point where it's time to file bankruptcy, and our friend from the office is here. Many of you have seen this clip before, but Krystal, once you are deciding that your client ought to file bankruptcy, talk about the different chapters, if you would, please.
I actually get to kick this one to Judge Faris. Few slides get to get kicked to the judge, but this isn't one of them.
Go ahead, Judge.
Okay. All right, I got it. So there's a number of different types of bankruptcy. The three listed on the slide are by far the most common. Chapter 7 is the one that most people think about when they think of bankruptcy. Basically, the debtor comes into bankruptcy court, files a petition saying, I need some help. They turn over all their assets except for certain assets that are called exempt to a bankruptcy trustee. The trustee's job is then to sell those assets and divide the money up among the creditors, usually pro rata. Some creditors get priority, but usually pro rata. It's available to individuals and businesses. Pretty much every kind of business, as well as natural people, can file for Chapter 7 relief. The benefits of it are it's very fast. If everything goes normally, it takes about 120 days from filing the petition to getting the discharge, which eliminates virtually all of most people's debts. It's also relatively inexpensive. In Hawaii, kind of the standard going rate, maybe you can correct me on this, Curtis, but I think the standard going rate for a Chapter 7 attorney's fee is about $1,800. That sound about right still, Curtis, or has inflation struck us there too?
Well, inflation's striking everyone, but yes, 1,800 to 2,000 is the range.
Okay. The second most common, I should say, at least in Hawaii, I hate to use the Hawaii example all the time, but we're an island too, right? So how else can I do better? That's about 60 to 70% of our cases are Chapter 7. About 30 or 40% of our cases are Chapter 13. Now, Chapter 13 is only available to individual debtors, not companies, and only to people who have a regular income. And the idea is the debtor gets to file a plan pursuant to which the debtor will make payments over a period of usually 3 to 5 years towards creditors. The upside of Chapter 13 for debtors is that your assets aren't liquidated. No trustee is appointed to take over and liquidate the assets. Another benefit is you can propose a plan under which you can cure a default on a mortgage loan or on a car loan and keep your home or keep your car. You can also use it as a vehicle to get some time to negotiate a workout with a mortgage lender. So it lets you keep property, but there's a cost that goes with that. You have to pay for 3 to 5 years, and you only get a discharge if you complete all those payments at the end of 3 to 5 years after confirming a plan. So most places, only about 1/3 of the people who start in Chapter 13 actually end up succeeding. For the right people, it's great. For a lot of people, it's not so great. Another disadvantage of Chapter 13 from the debtor's perspective, maybe an advantage from the lawyer's perspective, is the fees. In Hawaii anyway, the typical sort of starting fee for a Chapter 13 case is around $5,000. Quite a bit more than Chapter 7, but the potential benefits are also quite a bit greater. The third chapter you've heard of is Chapter 11. You've probably heard of this most commonly in the case of really, really big businesses, Lehman Brothers, PG&E, Purdue Pharma, et cetera. But it's also available for all people. Individuals can file 11, businesses can file 11, any kind of business organization. In Chapter 11, the debtor gets to propose a plan, which is much more flexible in its terms than a Chapter 13 plan. And that plan gets submitted to the creditors for a vote and submitted to the court for confirmation. And if it's confirmed, that takes care of the debts. The debtor has to comply with the plan. And if that's done, then everything's taken care of. The downside of Chapter 11 is it's quite a lot more expensive. It's hard to even start with a minimum figure for Chapter 11. Tens of thousands of dollars of legal fees is probably on the very low end for Chapter 11. On the higher end, I recently read that some of the New York lawyers doing Chapter 11 work are now billing close to $2,500 per hour. So it gets pretty expensive. The one advantage is there's no trustee, so the debtor's management stays in control of the company and gets to sort of shepherd this reorganization process. There's also procedures built into Chapter 11 that allow the debtor to override objections. It's elegantly called cram down. You force the plan down the throats of the creditors who don't necessarily want it.
So Judge Faris, Chapter 11 is an important concept in bankruptcy, but we're not going to really spend much time talking about that today. In fact, we've pretty much spent all the time we're going to talk about it, but we do have 2 other sessions coming up on the next 2 Mondays. Next Monday, Judge Faris is going to be featured talking about bankruptcy appeals. And then the week after that, we have Chuck Choi from Hawaii and Carolyn DeJang from LA. They're going to come in and join us for the Chapter 11 discussion with Ching. But Judge Faris, we've now mentioned a couple different times bankruptcy appeals and the bankruptcy appellate panel. In places other than Guam, where we have a district court hearing the bankruptcy cases, where do appeals go from a court like Arizona or a district like Hawaii?
Right. Well, where there is a separate bankruptcy court, which doesn't include either Guam or the Northern Marianas, appeals from bankruptcy court orders go to, well, it's more complicated than that. Circuits are given the authority, but are not required to set up bankruptcy appellate panels, which are basically staffed by bankruptcy judges. The Ninth Circuit has set up a bankruptcy appellate panel. There's 6 of us who sit on the BAP. So if you're in the Ninth Circuit, but not in Guam or the Northern Marianas, and you appeal from a bankruptcy court order, your appeal initially goes to the bankruptcy appellate panel. But every party to that appeal has an opportunity over a 15-day period, I believe it is, to say, no, I don't want to be in the BAP. I want to get in front of a real judge. I want to get in front of a district judge. And in that case, the appeal is automatically shifted over to the district court. Now then, if somebody's unhappy with either the BAP's ruling or the district court's ruling, the appeal would go on up to the Ninth Circuit. You in Guam and the Northern Marianas kind of cut out that middle part, go straight to the Ninth Circuit.
Okay, great. But anyway, I hope people will take note that the bankruptcy appellate program is next Monday, mainland time, Tuesday morning, Guam time and Saipan time. And then the following week, same time as the other 2, and that's Chapter 11. So now, Krystal, let's go on and talk a little bit about just a schematic that we've got on the screen, just a very basic flow of how things work in bankruptcy, if you would, please.
I use this schematic, as Judge calls it, to explain to my clients, my potential bankruptcy clients, what bankruptcy is all about. I hope that it simplifies the process and gives it to you in just a minute or two. You can give me your feedback later on your comments, but I tell my clients this little black stick figure on the bottom left corner represents you. And I don't have all the details just yet, but above you is your cloud of stuff. And if you decide to go forward, then everything in your cloud of stuff is going to be disclosed in the bankruptcy court. And I take that opportunity to tell them bankruptcy is like, provides a lot of substantial amount of relief to any person who files. But in order to get that, you have to open your financial book and say, which page would you like to read? Here it is. It's open and available to you. So you'll disclose everything. All your stuff will be disclosed first under penalty of perjury on signed documents. And then shortly after the case is filed, you'll attend a meeting of creditors where you're sworn in to tell the truth, the whole truth, and nothing but the truth. And we'll talk a little bit more about that meeting here today. And a couple of the questions during that meeting, many of the questions during that meeting by the trustee to the debtor relate to those documents that were signed under penalty of perjury and outline all the assets and the debts and the income and the expenses and financial affairs. And so the debtors are attesting, again, first by pen signature and then second by verbal confirmation that everything was accurate in those documents. So it's an important, I think, from the very first meeting with debtors, it's important to be relaying to them the process and the need to be complete, accurate, and truthful, I say, in all your dealings with me, with the trustee, and with the court. But the legal concept here is that everything in your cloud of stuff becomes technical, legal property of the bankruptcy estate, your bankruptcy estate. Which is kind of like a third person in the room with us, I tell them. And it becomes the technical legal owner of your stuff. Now, generally speaking, no one's going to see your stuff, but they're going to see your paper outlining what your assets are, and certainly be doing their own due diligence to see what your stuff is all about. You can't sell your home while you're in bankruptcy. The asset, the home, is legal property of the bankruptcy estate, and the title company would put a halt on the sale. So you have to just preserve your status quo, keep everything just the same as it was when you filed while the case makes its way through the process. At the bottom of the bankruptcy estate, which I think of as kind of like a funnel, there's a hole in the bottom of every funnel. And at the bottom of the bankruptcy estate, the hole, all your exempt items, and we're going to talk about what exemptions mean, but your exempt items are the things that you get to protect from your creditors and from the bankruptcy trustee. And those are going to fall out the bottom of the funnel and get returned to you through the process. So your legal rights, your legal ownership of those items will be restored to you once your bankruptcy case closes. And that's not necessarily the same date as your discharge. And the discharge is the piece of paper that you're after in this process. You want that relief from the debts that you had, that you listed in your bankruptcy documents. And the discharge is what ends what I consider to be the debt side of a bankruptcy case. But often, and especially in a Chapter 7, which is usually what we're talking about with our potential bankruptcy clients, at least initially,
Good morning.
is that there is any idea where that's coming from so we can mute it?
Yeah. I just got the news that the
the
buyer has already signed the.
There we go. Thank you. In a Chapter 7 context, a Chapter 7 trustee is assigned to the case, and he or she is going to be looking to you to give them any assets that you have that are not exempt, any items that you're not allowed under the law to protect from your creditors. And a common example in Arizona, I'm not sure if it's true in Guam, but is a tax refund. Tax refund monies trustees are ready to receive because those monies are not protected under the law for you, the debtor. They are property of the bankruptcy estate and subject to distribution by the trustee out to your creditors. I also go over the list of exempt property, and Curtis is going to jump into the exemption topic here next with you.
All right, Curtis, I'm not going to go on the next slide. Rather, we'd like to see your handsome face. Talk a little bit about what an exemption is and how it differs from jurisdiction to jurisdiction.
Thank you, Your Honor. So yes, as Krystal mentioned, the exemptions are very important because this is what the debtors are allowed to keep for themselves after the bankruptcy is done. And the bankruptcy code allows debtors on Guam to make a choice between either exemptions based on Guam law, which are in the GCA, or you can choose federal bankruptcy exemptions found in the bankruptcy code. And you have to decide what's best for your client. You cannot mix and match them, so you have to recommend to your client what's best for them. The Guam exemptions, though, I will say, are generally extremely not generous. They seem to be quite old, There's one that allows people to exempt out a cow and a suckling calf and 2 sows and 15 hens and roosters and things like that. So it seems like it's a throwback from a different period. The dollar amounts are very low. Like debtors could keep tools of the trade up to a maximum of $25, which seems today almost absurd. The Guam homestead exemption allows the protection of $40,000 in equity for the head of household. So it's pretty modest, particularly in comparison to homestead exemptions in other parts of the country. Maybe Judge Collins, what's the Arizona homestead exemption amount?
It's
It
a little
depends.
controversial right now, but Krystal, what's the maximum you can hope for?
The maximum right now is 400,000 in equity.
Right.
So Arizona has a 400,000.
Some states have unlimited homestead exemptions, and if your client is extremely wealthy and is mobile, you might want to think about sending them to Texas or Florida.
But be careful about that. There's special rules.
True. Go ahead, Kurs.
So the Guam homestead exemption is only $40,000 for the head of household. It is much more common, I will just say, that for Guam debtors to choose the federal bankruptcy exemptions because they're a little bit more generous. They allow equity of motor vehicles, household goods, all sorts of things. The homestead exemption under the federal bankruptcy exemptions is $27,900 per debtor. So if it's jointly owned, then you can double that. And also relevant, there's an exemption, what we call a wild card or a catch-all exemption, which allows $1,475 on anything, and plus another $13,950 for a debtor to the extent they don't use the homestead exemption. So if they don't have a homestead to claim an exemption on, then they get an additional almost $14,000 per debtor for anything. So keep in mind also that in a Chapter 7 case, the Chapter 7 trustee is the one whose job it is to review the exemptions and raise an objection so that he or she can liquidate the assets and pay back creditors. But trustees generally are not very interested in liquidating your debtor's used furniture or household goods. There has to be something really significant of value in that group of things for the trustee to be interested in liquidating. So that's just sort of a practice tip. Exemption planning.
Kurs, one of the things that debtors are often concerned about, and I've come to learn that on CNMI and Guam, a fair number of people work for the government and have actual pensions or retirement funds. What's generally the rule there in Guam?
So generally speaking, retirement accounts like IRAs, 401ks are completely exempt, and your pension payments, your stream of payments coming as a result of your years of service for, say, a government, are also exempt. The trustee will not pursue that. So that's a big exemption, and that's part of what you need to be advising your client because they're going to be worried about things like that. And your job, as the attorney for the debtor, would be to maximize the client's exemptions. And just last point, just 95% or more of the Chapter 7 bankruptcies are cases in which there are no assets that the trustee has to liquidate after a debtor claims all their applicable exemptions. So so most times, if you plan it well, there's nothing for a trustee to liquidate to pay out to creditors.
All right, so that's exemptions, a very, very important part of a debtor's pre-bankruptcy planning, because sometimes you want to take non-exempt assets and put them into exempt form. But Curtis, a couple times now we've heard about trustees, and you are working for a branch of the Department of Justice called the Office of the U.S. Trustee. What's the difference between a U.S. trustee and a trustee in a bankruptcy?
So I don't know who came up with the terminology because it's very confusing, but the U.S. trustee, as Judge Collins mentioned, is part of the Department of Justice, and our office serves as a watchdog role over the bankruptcy process. Our office appoints private Chapter 7 trustees and Chapter 13 trustees to individual cases. So these trustees, the Chapter 7 trustee and Chapter 13 trustees, are private individuals. They're not government employees. They are appointed and overseen by our office. They have statutory duties. And so their job is generally to try and maximize the recovery of funds to pay out to the creditors. So their job is to try and get money to the creditors as best as they can within the scope of the bankruptcy laws.
Okay.
The U.S. trustee, going back to the U.S. trustee is a government entity. We have administrative functions where we oversee trustees. We hire them, we monitor them, we review their work. And then also we have a legal component where we actually actively participate substantively in the legal proceedings. So we monitor cases for abuse, debtor abuse, creditor abuse, and we have the standing to bring motions and complaints when we see those types of things occurring.
Curtis, if you see criminal activity in a bankruptcy, what is your office's role in that type of matter?
Yes, so this is federal law, and so there are federal bankruptcy crimes. If a debtor intentionally conceals an asset or intentionally makes a false statement, those are felonies. Our office has the job of reviewing, investigating those types of possible crimes, referring the matter to the FBI and the United States Attorney, where we assist them in investigating and possibly prosecuting people who violate those criminal laws.
Judge Faris, you've been on the bench for a number of years. Have you ever had occasion to see what you think looks like a criminal activity going on in a bankruptcy that's in front of you? And if so, do you have an obligation to refer it? Even if you don't have an obligation, where do you refer it if you do?
We do have an obligation to make criminal referrals. I have never done that, mostly because I think Curtis's office has beat me to the punch. We've had a few debtors in Hawaii that go to prison for one thing or another, concealing assets. I recall in one case, there was a meeting of creditors. Part of the bankruptcy process is the debtor has to come in and answer questions. In the middle of the meeting of creditors, the FBI burst into the room, arrested the debtor, and dragged him off. Because he had taken a tax refund that was supposed to go to the trustee and instead had given it to his wife, or it's not his wife, actually, I had that wrong. It's his mother and his girlfriend. His wife didn't get any of the tax refund. That cost him 5 years in prison. So it does happen.
All right, Curtis, I'm looking in the chat box and I'm seeing Elizabeth Cruz indicates that the U.S. trustee is more debtor favored, only because I just heard trustee is supposed to be maximizing debtors exemptions versus U.S. trustee trying to liquidate. Correct on the first question. You want to comment about that, Curtis?
Well, whether or not we're more creditor or debtor oriented.
What's your view?
Well, we monitor cases for both abuse by debtors and creditors. The fact of the matter is we probably review debtors more closely than we do creditors. Creditors we're monitoring for Chapter 13, certain types of filings in the Chapter 13 case. But in Chapter 7 and Chapter 13, if a debtor conceals an asset, we will definitely investigate those and may bring an action, a civil action in the bankruptcy court, and then may also refer the matter to the United States Attorney for a possible criminal prosecution.
Okay, thank you. Krystal, I'm going to turn to you because I'd like you to talk a little bit about some of the ethics and perhaps getting paid in a bankruptcy. But to get started, I'm going to go back to the screen share here, and we're going to blow by Curtis's discussion of exemptions and his watchdog role at the U.S. Trustee's office. Now let's talk about ethics issues that you often deal with when you're looking at a debtor case.
Yeah. So I think the first common question or common issue is I often have individuals coming to me saying, I want to file bankruptcy for my business. That's the common first step. And I have to dig into those issues because oftentimes a business bankruptcy isn't going to solve all of the problems of the world. If we're looking at an individual, many individuals that are running small businesses sign lots of personal guarantees. Sadly, a lot of them don't realize what they're signing. And those personal guarantee obligations can't really be fully addressed through a business bankruptcy. And so oftentimes we either end up with two bankruptcies, a business bankruptcy and an individual bankruptcy. Timing can be different in many cases. Or, often other scenarios is the question becomes, should the business even file? Sometimes the better solution is that the business just needs to shut down and you maybe need to go get a W-2, a normal job, and you need to go through a personal bankruptcy because back to the, can you ever overcome these debts? Can the small business owner ever overcome the large personal guarantee obligations that they have, entered themselves into? And oftentimes the answer is no. And if that's the answer for the individual, then it could very well be that a business bankruptcy isn't going to solve all of the problems. So the who is your client, I think, is a good first, very important question, and not something that you can take the client's word for. You really have to review the documents and make sure that you're helping them understand what it is that they signed and what those, what the ramifications of those signatures are. If they only sign as agent of the business, not as personal guarantor, that could be a different discussion. Maybe in that scenario, business bankruptcy is a good option. But as we've talked about, a trustee, and I don't know if we've talked much about how a trustee gets paid, but generally speaking, in a Chapter 7 case, a trustee gets a fee that's around $60 per case. In order to get paid more, and the trustee does a decent amount of work in every single case, in many cases there's a lot of work to be done, and the only way the trustee is going to get paid more is if he or she collects something for the benefit of the unsecured creditors. So they are an eat what you kill sort of an organization. They're very motivated to dig, scratch, and see what they can find. And sometimes at the end of the day, they dig, scratch, see what they can find as your debtor individual is paying for that service, for you to help them with that service. And there's nothing in the corporate case for them to even find. But they're looking for ways they can go after the individuals. Some individuals don't run their businesses very well. I'm sure we all have experienced that. And that may give a business bankruptcy trustee the ability to sue the individual business owner for not having done something correct, or maybe for having done something incorrect. And so it could put the individual even more in the direct line of fire than they otherwise were sitting in. And all of that needs to be considered before you figure out who's going to pay your fees. I tell my clients I have to disclose to the court who paid my fees. And my best answer, of course, honest, always answer is my client is the one who paid my fees. I don't want to be paid certainly by any creditor. I'd prefer to not even be paid by mom, because, sometimes there's creditor-debtor relationships with mom that they don't always care to tell you about. So I just really would rather my client be the one to pay me, so that I can honestly tell the court my client is the one that paid me. And obviously that helps to avoid communication issues and who are we taking direction from, because when the client's the payor and the client's the client, there's no question about who's making the decisions. The when will you be paid is obviously very important. I often tell my clients, in Chapter 7 cases, I really can't be your creditor and your attorney in the bankruptcy case, which means that I need to be paid what I estimate my fee is going to be for your Chapter 7 case in full before we file the case, so that I have, what I estimate is your fee for the case paid and received and earned upon receipt. I don't know how the ethical rules are in Guam or in Hawaii, but here in Arizona, we have earned upon receipt retainers. And it's essentially, at least arguably, a flat fee for the basic scope of services required in every bankruptcy case, which brings us there to the next one. What is the scope of engagement, and are there things that we should be carving out? In some, not very many, but in some bankruptcy cases, adversary proceedings arise. There are certain things that creditors could pursue a debtor for, even though there's a bankruptcy pending. Things like fraud.
Describe what an adversary proceeding is, first of all.
It's a separate litigation matter within the bankruptcy case. It starts with a complaint and an answer, just like, at least to my knowledge, just like outside of the bankruptcy world, litigation happens. But the causes of action are limited, and they're discreetly provided in the bankruptcy code. Things again like fraud or breach of fiduciary duty, or you'll see it later, willful and things done with willful and malicious conduct, injury that's caused by willful and malicious conduct. So those specific actions can be brought in litigation, in mini litigation, if you will, within a bankruptcy case. It creates a whole separate proceeding within the bankruptcy case. Those aren't common, as I said, and typically not something you want to charge a client for before you're going into a case, not knowing if it's going to arise. The creditor is going to have to choose to file that adversary by a short deadline, usually about 90 days after the bankruptcy case is filed. So it's an unknown. And so oftentimes we carve out fees related to any adversary proceedings. If any adversary proceedings are filed, that would be on a separate post-bankruptcy engagement agreement and separate fee structure.
Let's stop right there for a second, because Judge Faris, my question for you is, just because a retainer agreement pre-bankruptcy between the debtor and the attorney says that the attorney is not going to handle this adversary proceeding where somebody is seeking to deny a discharge, do you nevertheless say hey, lawyer, you're in the case, you made your appearance, and you're here for all purposes until I let you out?
I will allow exclusion of those kinds of proceedings from the retention, because I think if I didn't, very few people would be able to afford lawyers for bankruptcy cases. What does concern me is I want to make sure that when that retention was agreed on, the lawyer explained to the debtor what that meant. I have concerns about that, because the debtor goes into bankruptcy and then somebody comes along to say, well, you did such bad things, you're not entitled to a discharge. And all of a sudden the lawyer says, oh, you're on your own. You know, that I could see how a debtor would be nonplussed by that. So I want to make sure that there's clear disclosure so that the client understands the implication of that exclusion from the retention.
Let's take a different scenario. Let's say before the bankruptcy, to put together these schedules and statements, the lawyer would charge, let's make up a number, $750. Could the retainer agreement say, I'll do all of that and then I'll file the case for you, but after that, I'm not doing anything? Would you permit that from a judge's perspective because they have appeared in your case?
Yeah, I have not had to face that question. That's a very, very controversial practice. Some places it's allowed, sometimes it's not. The U.S. Trustee's office has, it's called bifurcation of fees. By the way, you get one fee for your pre-bankruptcy work and then another fee for post-bankruptcy work. The U.S. Trustee's office has set up guidelines under which the U.S. Trustee won't object to that. To my knowledge, I don't think anybody here has attempted that. My concern would be, number one, does the debtor really understand the implications of that? Do they really understand that this is something different? And also, is it realistic to say there's really two completely separate agreements? Because I have difficulty believing that somebody would kind of knowingly and with full information agree to be put into this legal proceeding and then immediately abandoned, you know? So I think that the disclosure questions trouble me. The allocation of the fee between post and pre-work troubles me, because you know, if you do a case right, it seems to me you do most of the work before the petition is filed. If it's properly prepared, the case is going to go smooth. And most of these cases I've seen, there's a very small fee for the pre-petition work and a much larger fee for the post-petition work. And that's not the way it ought to be done, in my view, not the ideal way for the debtor to do it.
And yet, Krystal, it is done that way, certainly in Arizona and other places around the country. Explain a little bit about how a zero-down bankruptcy works in some of these other jurisdictions.
Yeah, and just a matter of disclosure, I do not do it because I completely agree with Judge Faris, and I often tell my clients, if we do, it often feels like I'm making you work hard, but if we do this part well, then the case will go smoothly. So I am not an advocate of zero down or minimal down, but essentially it is what you heard. It's, you know, I usually have heard of things like $500, you know, $250, $400, some small amount. And I think ideally also debtors to pay the court filing fee to get into the case. And the attorney prepares some basic level of the documents. I mean, you've heard a little bit about the schedules and statements today. They're generally 60 to 80 pages, again, especially if they're done well. In every case, 60 pages minimum. And when I sign a petition, I believe that I'm signing saying I've made diligent inquiry into the debtor's affairs, and nothing in this packet of 60 pages of information is incorrect or incomplete. I don't see how any attorney can do that for 500 down, but that is essentially what they're doing. They're signing one engagement agreement for a minimal fee to do some minimal level of work. And then as soon as the case is filed, they are giving the debtor a new engagement agreement to review with, of course, opportunity to confer with other counsel and choose whether or not they're going to sign that second engagement agreement and continue to pay that attorney on a post-bankruptcy basis. It's a troublesome setup, but it is happening all across the country in various areas.
All right, now let's turn to a happier topic, and that is at the beginning of the presentation, I said the four of us really, really love bankruptcy. Judge Faris, give us your best love story. Why is it that you love bankruptcy as much as you do?
Well, there's actually a lot of reasons. It's like love in that respect. You don't love somebody for one reason, but it's intellectually challenging. It's very interesting. There's also all those kinds of problems. But the other thing is it's one of the few areas of the law where you can actually do some kind of unambiguous good for somebody. My wife, as a physician, she became an obstetrician because she felt that that's the one area where, you know, most doctors oftentimes deliver really bad news to people. If you're an OB, you often deliver the most wonderful thing that's ever happened to a person. And bankruptcy is kind of like that, not the same, but kind of like that, because, you know, most of the time, if you do your job, you're going to rid these people of a lot of debt. And it's hard to overstate how much pain these people are in when they start off. Another story I often tell is I had a client when I was in bankruptcy. I put him through a Chapter 7 case. We went to his meeting of creditors. He listened to a bunch of other people tell their stories. We finished up his meeting. We're walking back to my office, and he told me that he could never do my job. And I said, "Why is that?" He said, "That's the most depressing thing I've ever seen." And that's a particularly strong story because at the time, this guy was a psychiatrist working at the state hospital here in Hawaii, where they put people who have been acquitted from crimes due to insanity. And he thought my job was depressing. So these people start out in a whole world of hurt, and you can make their lives meaningfully better in a short period of time. And that's a good feeling.
Curtis, how about you?
Well, I like the idea of the concept of bankruptcy where people who are in financial distress need a way out. I mean, they absolutely need a way out. And I like being part of a system to make it work well, where the people who are deserving of a bankruptcy discharge get the discharge, they do things right, and they get the relief that they're asking for. And if, you know, in the very small minority of cases where people are not acting correctly, then, you know, we can probably try and stop them. So it's a good system, not perfect, but a very good system to get that type of relief to needy people.
Now, Krystal, you are working with those needy people. You see people come in hysterical or depressed situations. Why is it you like doing debtor work in particular?
And I would echo everything Judge Faris and Curtis just said, but I'll try to keep it short. I think that my biggest takeaway, I could talk about this all day long, but my biggest takeaway is I get to meet two different people in one client. Right? I get to meet that distraught, you know, emotionally overrun. I've tried everything. You know, I can't believe I'm having to talk to a bankruptcy attorney person in that first meeting. And I just got the chills because I literally get to meet an entirely different person at the end of our relationship. And the expression of, "Oh my gosh, thank you so much for helping me get that fresh start." It will never, ever, ever get old. It's something that it's such a power. Again, bankruptcy is so powerful. It can provide such substantial relief to people to be the one that's helping them get that and see it on the other side. And I've had many occasions to say, "I know times are tough in the marriage, but please just hang on. Let me help you through this part of your life and try not to focus on that part until this part's done." And I think I've been able to help save a lot of marriages in that regard too, because finances put a lot of strain on marriages. And if we can help them overcome this, they can help themselves overcome the other bad parts of life. It's incredible.
While I agree with all three of you, one of the reasons I really like bankruptcy and what I try to talk to my law clerks and externs about, the law students I work with, is in bankruptcy, you do everything lawyers do. You do litigation, you do deals, you do drafting, you do depositions, you're doing finance and business related work. Just about every discipline you can imagine in the law comes into bankruptcy. Environmental issues, personal injury issues, pension issues, you name it. Judge Faris has seen just about every discipline you can imagine. So if you're intellectually interested and want a varied practice, bankruptcy is really right there. All right, so Krystal, we're going to go to the next slide and talk a little bit about some of the planning issues for a Chapter 7. Let's blow through these pretty quickly, if you would, please.
Yeah. So Chapter 7 is an ideal spot for most individuals to be. It's the quick get your discharge and move on with your fresh start, but you have to be eligible. And the eligibility starts with a means test in many cases. It looks back at the last 6 calendar months of income and then assesses expenses as well and tries to help you determine if you're eligible as a debtor to file a Chapter 7 bankruptcy, or if it maybe would be an abuse, if you should be in a payment plan chapter like a 13 or an 11. There is a non-consumer debt exclusion to the means test. So, and I think it's a very important first step when you're looking to help a debtor. If they have a lot of student loan debt or a lot of medical bills, and there are a lot of tax debt, there are a few other things that are non-consumer debts, it might be an easy path around the means test, which opens up a whole other area of Chapter 7 for individuals. So back to that personal guarantee problem that I mentioned earlier, it's a good way to get in. Exempt versus non-exempt assets is a big consideration. If the person has a lot of non-exempt assets, remember in a Chapter 7 context, we're handing those non-exempt assets to the Chapter 7 trustee for sale. There may be a way to keep the asset and pay the creditors the value of the asset in other chapters. So it's an important thing to be considering when you're thinking about what chapter might be best. Business owners in a Chapter 7, there's a risk that a Chapter 7 trustee can sell the business owner's interest, right? So if they have a gas station, for instance, that the trustee can just sell the interest in the gas station and put a new Joe in there as the owner, that's more risky. It's personal service business that the debtor operates as a physical therapist, for instance. Obviously, that's much more difficult for a bankruptcy, individual bankruptcy trustee to sell that business interest. So again, something that needs to be considered. Tax issues are a big one in bankruptcy. Other chapters are sometimes better for people with big tax issues or with any tax issues. I think it's important to note that anytime there are tax issues in a case, it's important to take a special look at that case. Generally speaking, tax obligations that were due more than 3 years prior to the filing date, the bankruptcy filing date, and when the returns are timely filed, they are dischargeable. So it's possible to actually wipe away some tax debt in a bankruptcy case. But filing date is critical. And so making sure that you're assessing those tax issues, getting the information you need to assess those tax issues and figure out what day to file and what chapter to file is really important. Chapter 7 trustees looking back at recent transactions and transfers, in detail. Again, they're eating what they kill. So they're looking to see very thoroughly what may be in the debtor's past that they might be able to unwind. The trustee has what are called strong arm powers that can be tapped into to unwind transactions that weren't done properly. And that's more prevalent, certainly in Chapter 7. A Chapter 13 debtor can address those issues on his or her own without involving a Chapter 7 trustee. I mentioned the strong arm powers, and then we've already talked a little bit about non-dischargeability issues too, going back to that adversary proceeding. If certain creditors feel that they have a path to seeking non-dischargeability under the bankruptcy code, they can bring that adversary proceeding. And those are a little bit more common in a Chapter 7 because the debtor is trying to get out on his fresh start quickly, as opposed to making a payment plan to get creditors what he can over a period of time.
Okay, so I'm going to now turn to Chapter 13 and ask Judge Faris to talk a little bit about some of the pluses and maybe minuses of a Chapter 13.
Sure. So there's a number of things you have to think about when deciding whether a client should be in Chapter 13. One of them is the eligibility limit on the amount of the debt. The person can't have more than $2.75 million of debt. That excludes debts that are contingent and debts that are unliquidated. So this is a reason why a person might want to file a Chapter 13 before the judgment is entered in that big tort suit against them. Because until the judgment's entered, that's an unliquidated debt, which doesn't count against the debt limit. After the judgment's entered, it's liquidated, and your client may become ineligible for 13. So it's partly an analysis problem, partly a timing problem. The main reason, at least in Hawaii, why people find Chapter 13 more appealing is it gives them a chance to save the house or the car. A lot of Chapter 13 turns on the budget, and I think it's very important for the lawyer to work carefully with the client and make sure there's a realistic budget that can back up the case. For example, the typical way of solving a problem with a mortgage in Chapter 13 is to propose a plan which we call a cure and maintenance plan. I'm going to maintain my regular monthly mortgage payments, or resume them anyway, and then I'm going to pay more, and that more will be enough to catch me up by the end of the plan, which sounds great, but then you got to ask them, look, the reason you need this bankruptcy is you couldn't make your regular monthly payments, but now you're proposing to make more than your monthly payments. What's changed? How are you going to make that happen? And a lot of people won't really have a realistic answer to that question. Also, they won't have a real handle on their budget at all. So there may be room to counsel with them and help them get things straightened out. If things blow up in Chapter 13, if the plan is just not working out, one advantage is the debtor has an automatic bailout. All you have to say is, I want to dismiss this case, and the court must dismiss the case. There's really no way of stopping the debtor from getting out who wants to get back out. And I think that's useful and also gives people a sense of comfort. One plus of Chapter 13 is that some of the debts that are not discharged in Chapter 7 are discharged in Chapter 13. There's kind of a long list of debts that aren't discharged in Chapter 13. Most of those I've never seen actually used in practice, but a couple of them are realistic and are dischargeable in 13. The most common one is in Chapter 7, alimony is not dischargeable. Support payments, child support payments are not dischargeable. And also what I call equalization payments are not dischargeable. So if in the divorce settlement, one spouse got more property than the other and agreed to pay the other spouse for the value of that property, that equalization payment also survives a Chapter 7 discharge. In Chapter 13, the equalization payment is discharged. You got to pay the alimony and the support, but the equalization potentially goes away. Now, you can imagine how amused the ex-spouse will be by that proposal. So if you make that proposal, you've made yourself an enemy who's going to try and tank your Chapter 13 case any way they can. Another category of debts that are not dischargeable in Chapter 7 are debts that are for willful and malicious injury to person or property. So if you deliberately go out to hurt somebody or deliberately go out to hurt the person, and when I mean deliberately, I mean you intended to inflict the injury. Not that you intended the action that caused the injury, but you intended to inflict the injury. Those debts are not dischargeable in 7. In 13, you still can't get out from under the debts for willful malicious injury to person, but you can get out from under the debt of willful and malicious injury to property. So if you beat up a person and slash their tires, you can't get rid of the liability of the person either in 7 or 13, but in 13, you can get rid of the liability for slashing the tires. Not that big a deal for a lot of people. In Chapter 13, there are many of the same issues that you see in Chapter 7 about pre-bankruptcy transfers that can cause problems in a Chapter 13 case. The Chapter 13 trustee doesn't, or debtor rather, doesn't have to go out and get that money back, but the debtor has to propose payments to the creditors that are at least as large as what they would have gotten in a Chapter 7. So the debtor may have to provide payments that are equal to the amount of those inappropriate pre-bankruptcy transfers. That has to be factored into the payment plan of the budget. One advantage is sometimes a bankruptcy filing is good because it just slows people down. Litigation sometimes reaches a fever pitch. People really want to push and push and push, and just forcing everybody to take a step back, stop, and think a little bit can sometimes tame that hyper-aggressive litigant and make everything go a little bit smoother. So there are pluses to Chapter 13. There are some minuses. It requires careful analysis.
Thank you. Now, Krystal, one of the things I'd like you to talk about for a moment, because when you've done that, then I'm going to turn it open to anybody who would like to ask a question, because we are definitely on the home stretch here. Student loans are a very, very big topic all around the country. Over $1 trillion in student loan debt that's out there. A lot of it's in default. There was forbearance during COVID. Those forbearances are largely over now. The conventional wisdom I always hear from people is, well, you can't get rid of student loan debt in bankruptcy. Talk about that very briefly, if you would. Is it hopeless?
Yeah, I think that's been more true until the last couple of years, but the Department of Education has released additional guidance to address this specific issue. I think the need is very great. There are new forms that have been created, attestation form that the debtor needs to review and sign, and I'm not intimately familiar with it, but I think it's much more feasible for someone that has put effort into getting their loans repaid, but has not been able to do that, even if they're earning a decent living. I mean, I've seen some cases come down that you pretty much have to be living in a van down by the river in order to get your student loans discharged in historical times. I mean, even just in the last 10 years. But with this guidance, I've heard that there's a very high success rate. I've heard in the high 90s success rate for adversaries that have been filed. And again, this is an adversary proceeding filed specifically related to the student loan obligation. That guidance just came out within the last year. So it's still very, very new, but it is creating a new avenue for addressing student loans.
Okay. All right. Now, one more question for you, Krystal, and then we'll turn it over to anybody who'd like to ask a question. And that is, how do you attract, as a debtor's lawyer, how do you attract your cases? How do they come to you?
Yeah, I'm very grateful that my answer is mostly word of mouth. AVO is a wonderful website. AVVO is a wonderful attorney rating website where clients can go and rate their attorney and provide commentary. It's kind of like a Yelp for lawyers. And surprisingly, AVO does a lot of advertising, even on the television. I've seen TV commercials by AVO. So they are doing what they can to get the word out about the attorneys that are on their website. I do a minimal level of advertising with AVO. It's really, really small. As I said, I'm very grateful to say most of my business comes from word of mouth. And I think, when we do a good job for our clients, I'm sure many of us already know this, then it comes around full circle. And bankruptcy is very common, maybe not so much in Guam these days, but I think once there's the word out there that, Krystal does a good job, it begins to spread. And then we start to get those calls. I got a call recently that said 3 people gave me your name and they don't even know each other. And I had to blush with that because it's just highly appreciated when it comes back around that way.
Well, like anything, it sort of builds on itself, but in today's media world, these AVO type apps really are something that drives business for an awful lot of lawyers.
I
Not
think
so much
so.
advertising.
Even Facebook ads and Instagram ads. I mean, I'm not very tech savvy, but I know a number of our bankruptcy attorney colleagues are tapping into those advertising sources as well.
Okay. All right, so now is the time. If anybody has any questions, I'd like you to unmute and ask your question. And while you're getting ready to think about what your question is, I'm going to ask Karen Quittlong to come on screen, show yourself, and I'm going to ask you to tell everybody who you work for and why you love bankruptcy, Karen. Judge Tydico Gatewood, where is Karen?
Sorry, I'm here. My headset wasn't turned on because I wasn't planning on speaking.
There she is.
Hi, everyone. I love bankruptcy because it's a different area of law. It's sort of like the chemistry out of all the sciences. And so we hope that we attract enough people from today to log in for the next couple of weeks and to continue joining us for these bankruptcy trainings.
All right. So in Arizona, everybody wants to know who my law clerk is. That's why I've asked Karen to come on screen, because they can actually help your life, because you can't call the judge directly, but sometimes you can get through to the law clerk and they can point you in the right direction. Not going to give you legal advice, but they're often very helpful. And I think Karen is exactly one of those people. All right. We see in the chat room, we've got Brendan Lady is asking the question, when financial disclosures in bankruptcy expose criminal liability, what are the prospects of successful asset forfeiture? Curtis, you want to take a swing at that one?
I'm sorry, can you repeat that question, please?
When financial disclosures in bankruptcy expose criminal liability, what are the prospects of a successful asset forfeiture?
Well, that's a question for the U.S. Attorney's Office for asset forfeiture. If there is a crime involved, then there's a possibility that the United States Attorney's Office could seek to forfeit assets as part of the criminal enterprise. I haven't actually seen it, however, in bankruptcy cases very often. And I will say that in Guam, I've seen prosecutions for bankruptcy crimes. Doesn't happen too often, but it does happen on occasion. I have not seen a forfeiture action in those criminal proceedings.
All right, well then,
Can I add to that also?
I'd like an advisory opinion from you, Judge Faris.
I was going to say, if I were a prosecutor, I wouldn't bother with the asset forfeiture, because this undisclosed asset, the concealed asset, belongs to the bankruptcy estate forever, even after the bankruptcy case is closed. So all we have to do is ask Curtis to reappoint a new trustee. The trustee is now the owner of that asset, and the trustee can sell it and for the benefit of creditors.
That's exactly the statement I would have made as well. So thank you, Judge Faris. So Gregory Baca asked the question, can we get a copy of these slides? And the answer is yes. Go look in the chat box, and Charles White has put up the slides right there for you. And so has Krystal. All right, Krystal, you had a Bankruptcy 101 series link on YouTube. What's that all about?
Yeah, so I'm a co-executive director of Arizona Consumer Bankruptcy Council, a group of about 100 consumer debtor focused bankruptcy attorneys. And after COVID hit and we all went to Zoom sessions, we created a Bankruptcy 101 series. It's 10 different YouTube videos. Materials are available too. If you'd like them, you can always shoot me an email. I'll put my contact information in the chat, and you're welcome to contact me for anything. I'd be happy to help you along in your mission if you're going to jump into bankruptcy. But that YouTube link that I put there, you can watch all 10 of the Bankruptcy 101 series videos. I think they're fantastic, but again, I love your feedback. And then that's just the 101 series. We got a whole bunch of other videos that are available to non-members. So I just posted a second link there where you can access any of those additional topics. There are specific topics and much more broad topics. So hopefully there's something for everyone there. And then lastly, I'll put my information in the chat for anyone who would like to use it.
So Judge Faris, I love this next question, because when I was a lawyer practicing in bankruptcy, a lot of times people would say, I need to file bankruptcy because A, B, and C, but I owe money to my mom and I owe money to my neighbor, and I'm not gonna bankrupt them. What's the answer to that one? Because the question by Jay in the chat box is, what happens to debts that are not reported in the bankruptcy proceeding? Debtor forgot to include it or intentionally didn't include it. Are they going to get discharged?
Well, it's a weird counterintuitive answer, but the answer is, if there were assets in the bankruptcy estate, no, they're not discharged. But if it's a no asset case where basically the trustee files a report saying there's nothing here for anybody, then those undisclosed liabilities are discharged under Ninth Circuit law, based on the Ninth Circuit's strict reading of the statute. It really, if you were asked to make up a rule and guess what it should be, that's not the rule you'd come up with, but that is the rule in the Ninth Circuit.
Okay, great.
And that's something that's really hard, if I may, Judge. It's something that's really hard to know when you're first filing a case. There are many cases where you might think, oh, this is a no asset case, and something may pop up along the way that makes it an asset case, and that changes outcome for a non-listed creditor. So I tell my clients at this meeting, they're going to be asked, have you listed all of your debts? And they need to obviously honestly be able to say yes. So intentionally excluding a creditor is not an option. And I told them from the first meeting, they really need to dig through their records, rack their brain, make sure they're finding all the creditors and getting them listed, because you don't want to do all of this and then have a creditor pop up later.
And I would also say that whether it's an asset or a no asset case, if the lawyer knows the client is not disclosing an asset, the lawyer's got a problem. So you got to be careful about that.
All right, now those lawyers in Guam and CNMI that are on screen today are just getting their day started. I really, really appreciate your being with us. The one thing you don't want from us is to go into overtime, and we're already there. I'm going to turn it back though to Judge Tidingco Gatewood to wrap things up. Judge, if you would, please, or Judge Manglonia, something you'd like to add.
Hey, thank you very much, Judge Collins, and I hope everybody enjoyed today's presentation. I really appreciate Judge Collins, Judge Faris, our trustee Curtis Ching, and our attorney Krystal from Arizona for coming together. And I hope you learned a lot. There's a lot of resources that are available. And maybe Mona, do you want to say a few words? I know we have some of our Northern Mariana Islands attorneys here.
You're on mute, Judge. Judge Manglonia, you're on mute.
Mona, you're on mute.
I think somebody else has the button.
Oh, okay, somebody. I don't, let me.
Yeah. Maybe just a big thumbs up.
Okay.
She's looking good though.
So-
She's looking really good.
Okay, I can't hear. I'm sorry, Mona.
All right. Sorry to spring that on you. Oh, we have
There we go.
We really can't.
okay, I'm gonna mute that because it's so staticky. I'm sorry, Judge Manglonia, we couldn't hear you through all the static. But I think that really does bring us to the conclusion. Just want to remind everybody, take a look at that link in the chat box. You can download all of the PowerPoint, including some of the things we didn't talk about, but are interesting links. But please join us next Tuesday morning, and that'll be the bankruptcy appeals issue. And then the following Tuesday morning in Guam and CNMI will be the commercial component of this three-part series. Thank you once again for joining us. Have a good day.
Thank you, everyone.
This is Mossy, everyone. Thank you, Judge.